If I may continue with my Lord's permission. Just to complete that last part of yesterday's submission on the original intent, but I was at para 2.8 of my submissions on page 1324. But I'll be very quick in this part because this part has been shown to your lordships earlier. I just want to pinpoint the specific areas of the Constituent Assembly debates. My lord, I wanted to invite your lordship's attention. Page 1324, para 2.8. But under the draft article 175, my lord, just 2-3 sentences. My lord, if I may start, my lord, with the speech of Mr. B.R. Ambedkar. It was felt that in a responsible government, there can be no room for the governor acting on discretion. Therefore, the new proviso deletes the word in his discretion. My lord, then page over. My lord, only to the relevant part, because this has been read for your lordships. My lord, page 1325, the speech of Mr. T.T. Krishnamachari. But after about 5 lines in the bold portion, that the governor will not be exercising his discretion in the matter of referring a bill back to the house with a message. That provision has gone out of the picture. The governor is no longer vested with any discretion. If it happens that as per amendment number 17, the governor sends a bill back for further consideration, he does so expressly on the advice of his council of ministers. My lord, then the underlined portion below that, my lord. But there is some point of the bill which has been accepted by the upper house, which the ministry thereafter finds has to be modified. Then they will use this procedure. So, my lord, this was contemplated to be for the aid of, my lord, the council of ministers. My lord, then the next speech of Mr. T.T. Krishnamachari. My lord, if my honorable friend understands that the governor cannot act on his own, he can only act on the advice of the ministry, then the whole picture will clearly fall in its proper place before him. But after 2 lines, it is a saving clause and vests power in the hands of the ministry to remedy a hasty action that they might have undertaken or enable them to take an action which they feel they ought to in order to meet popular opinion which is reflected outside the house in some form or the other. For this purpose only, this new proviso has been put in. It does not abridge the power of the responsible ministry in any way, and therefore it does not detract from the power of the lower house to which the ministry is undoubtedly responsible. It does not confer any more power on the governor. On the other hand, it curtails the power of the governor for the position envisaged in the original proviso which it seeks to supplant. My lord, then, my lord, page over. My lord, this is one other important fact your lordships may kindly bear in mind. My lord, in para 2.9, I indicate, my lord, that when draft article 143 was being discussed, my lord, which is 163 today, dealing with the governor's discretion, my lord, one of the suggestions, my lord, made was that you cannot say that in the latter part of article 163, that except in matters where the governor is conferred a discretion. Lord, if your lordships, Lord, this speech has been read out to your lordships. Your lordships recollect, Lord, the speech of Dr. Ambedkar. Dr. Ambedkar said, one way of doing it is, here itself we say that the governor shall be aided by the advice of the ministry, except in articles X, Y, Z. But those X, Y, Z articles are to come later in the debate. We do not know what shape they will take. So as and when we reach those respective articles, if we feel the governor has to be given discretion,
we'll revisit this article, but then it was not revisited.
That's correct. So now what happens is when your lordship based the discussion in relation to draft article 143 in mind, where they said that if the discretion has to be conferred, we will do so expressly in those articles. Then when it comes to draft article 175, article 200, in contradistinction, what was provided originally in the draft article was in his discretion. Here, expressly it has been removed. But instead of providing it or for your lordships to inferentially read into it, that this will have a discretion. So first, draft article 143, they say, we will say wherever the governor is granted. May I read just 163 for a minute, my lord? Article 163. Right. Very well. Then I'll just skip. My lord, then, my lord, if I may move to the next point. So, my lord, this para 2.9 deals with, my lord, the twin action, where on one hand, in 163, they say that we will provide expressly, but when it comes to article 200, my lord, it was expressly deleted. My lord, then in para 2.10, I indicate, my lord, this has also been shown to your lordships that except in the other articles where express discretion has been conferred, with no discretion being conferred in article 200, my lord, it would not be possible to read in a discretion to the governor. My lord, then 2.11. My lord, this is the last submission on the second proviso. My lord, the second proviso, when it specifically says that the governor shall reserve the matter for the consideration of the president, my lord, where the powers of the High Court may be affected. My lord, that second proviso is actually, my lord, an indication of the fact that the governor normally would not have a discretion. He would be bound by the aid and advice.
We have already
Very
said that.
My lord, then if you
Where the parliament wanted to specifically provide a discretion, it has been provided in the second proviso.
That's right.
Therefore,
but I'm only bringing one other nuance. I
assume that the parliament, the Constituent Assembly did not intend to provide a discretion in other matters.
My lord, I'm making a slightly different nuance. While it was said in the respect of various other articles, including, my lord, Article 200 second proviso, I'm saying the second proviso of Article 200 itself is an indication of the earlier part.
So far as when it affects the powers of the High Court, there is a mandate to the governor that he shall not grant.
Yes, that's right.
Obligation. There is no discretion.
Yes, I'm sure I'm not able to get my nuance across. If you just give me 1 more minute, my lord. The point that I'm trying to make is that lack of discretion that is provided to the governor, my lord, is not indicative of a lack of discretion at the governor's hands. It's a lack of discretion at the Council of Ministers' hands, my lord, where they can do something which will abridge the powers of the High Court. Because if the Council of Ministers, who normally will guide the governor on what steps need to be taken, the governor is now granted, my lord, a separate exceptional power under the second proviso saying that here you are not governed by the Council of Ministers' advice. The Constitution enables the governor that other than the regular procedure contemplated under Article 200, where is otherwise bound by the Council of Ministers' advice, the governor here is not bound under the second proviso, even if the Council of Ministers asks him to assent or, my lord, send it back to the House at the most. My lord, he will have to reserve it for the consideration of the president. So the second proviso is indicative of the fact that the earlier part of Article 200, the governor has no discretion. My lord, then, my lord, what I have done for your lordship's kind consideration is.
What are the so-called words that you are trying to locate for the second proviso?
Yes.
For that reason. What is indicated? The governor shall not assent, that's all.
Provided that the governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law.
In the opinion of the governor.
That's correct. So, my lord, when the governor is now mandated by the Constitution that he shall not assent to, he shall not assent to even if he is advised to the contrary by the Council of Ministers.
So his discretion will prevail over the advice of Council of Ministers.
Correct. So where they wanted this to prevail, it was expressly provided. So, my lord, the scheme of Article 200 is, if the constitutional makers felt that the governor anyway has this discretion, it need not be expressly provided by the second proviso separately. The provision is indicative of the lack of discretion in the earlier part. That's the submission I'm making, my lords. Now, your lordships may kindly bear in mind, my lord, I'm dealing with the exceptions after this very quickly. I don't need to go into detail. My lord, MP special police case has already been cited for your lordships. My lord, though it arose in the context of 197 CRPC, my lord, the Supreme Court, my lord, in para 33, my lord, a specific question fell from the court. Is the governor bound by the advice of the Council of Ministers in a statutory discretion area, like section 197 CRPC? But 197 CRPC also, my lord, this honorable court holds that ordinarily, but even in that space, the governor is bound by the aid and advice of the Council of Ministers, except in cases where the Council of Ministers itself may be disqualified on account of inherent bias, or, my lord, where the interests of the chief minister or the ministers are concerned. My lord, that is at para 33. My lord, I don't need to show this to your lordships. My lord, what I have done at the foot of the page, but after indicating the, my lord, the carve out areas made even in a statutory space at page 1327, but this was also mentioned to your lordships. Vaishno Devi, my lord, Shrine Act confers powers on the governor separately statutorily. My lord, similarly, my lord, there are various state statutes which, my lord, provide that the governor shall act as the vice chancellor. My lord, there the Supreme Court has, chancellor, I'm sorry. My lord, the Supreme Court has taken a view that he operates in his capacity as a chancellor.
That has also been argued.
That's right. My lord, only thing, my lord, your lordships may kindly bear in mind is now, my lord, that there is a case where your lordships have seen this possibility of a inherent bias that may be available. Some of the cases that come up, and my lord, those are cases, I'm not touching on the facts of this case, but these are cases that have been decided by this honorable court. When Tamil Nadu wanted to make an amendment to the act and remove the governor, my lord, as the chancellor, replacing him with the chief minister, the governor, my lord, sits on that bill or sends the bill for consideration of the president. Your lordships may have to consider, since your lordships are acting in an advisory jurisdiction, which is much wider, but whether a governor who is otherwise conferred, my lord, this separate power under a statute, if the legislature is making a law wanting to remove it, is he inherently biased in trying to sit on that bill because he will continue to?
That's not a question for consideration.
I'm not that.
We will be only answering what has been referred to as,
Very well.
not any hypothetical question.
Very well. But then I